Mr. Weber has joined us as well.
Good morning, Your Honor, or afternoon. I think we're there.
It's close.
Almost. Mr. Jackson, how much rebuttal time would you like?
5 minutes, please, sir.
That'll be fine. You may proceed.
Thank you. May it please the court. Kevin Jackson here on behalf of the appellant, Judgment Enforcement Solution, Inc., as assignee of Chris Devaney. Your Honors, this is an appeal that's from the lower court granting a head of family claim of exemption that was entered in favor of one of the defendants, Mark Stalker, as well as the court entered an order granting his motion to dissolve the writ of garnishment. We're appealing that, and just as a brief history, there was a final judgment entered against Mr. Stalker for $767,740. Thereafter, the trial court issued a writ of continuing garnishment, which was served on Mr. Stalker's employer, Hennessy Construction Services. Now, Hennessy Construction Services is owned jointly by Mr. Stalker, the judgment debtor, and his wife, Catherine Stalker. The writ was served on them. They filed an answer saying that Mr. Stalker makes $140,000 a year. He's paid $2,692 a week, and pursuant to the writ, they're holding about $500 a week. Mr. Stalker then filed a claim of exemption, setting forth that his wages are not permitted to be garnished because he qualifies under Florida Statute 222.11 as the head of family. And if you look at Florida Statute 222.11, the disposable earnings of a head of family, which are greater than $700 a week, may not be attached or garnished.
That sounds, Mr. Jackson, that as I read the briefs, what you really need is a legislative fix.
Well, no, because what my understanding of what the case law says is the case law says that the court can look at the totality of the circumstances with the idea of the purpose of the statute and the legislative intent of the statute in mind. And I did cite a number of cases that stand for that proposition. Even the appellee in their answer brief cited to a couple cases, the Supreme Court of Florida case, Wolf v. Commander, and the Fourth DCA case, Mazzella versus Bonus. And both of them, every case that's cited by both sides say, look, you have to look to the purpose of the statute. You have to take the facts of each case in the totality of the circumstances of each case when deciding what to do on these types of situations, when deciding whether a person meets the definition of head of family. And most of them have, with respect to these types of cases, most of them have looked at the term dependency. Now, the term dependency isn't defined in the statute. So the courts must look to the facts of the case and other case law in order to determine, does this person meet the definition of dependency within the statute? And that's kind of what happened in this case, Your Honor. The court was presented with all of these facts that the supposed dependent in this case, Mark Stalker's wife, whether she was a dependent under the statute, whether she was dependent on him to survive, whether she was dependent on him for support. And the case law goes into detail, even the case law cited by the appellees that says, you look at, and I'll read it. The head of family exemption is designed to protect citizens against financial reverses and difficulties and to permit the citizen, when residing in Florida and head of family, to be secure in money coming into him for his labor and his services, thereby supporting his family and preventing them from becoming a public charge. So
I appreciate that, Mr. Jackson, but let's look at the statute itself. And I think it goes back to what Judge LaRose is saying, and it goes back to what Judge Covert was frustrated with, because when you think about it, what does the statute say? And the statute basically says that disposable earnings of head of a family mentioned that is greater than $750 a week may not be attached or garnished. And then and defines, and here's the key, head of the family as, and I quote, any natural person who is providing more than 1/2 of the support for a child or other dependent. So the language is providing more than 1/2 of the support. So going back to the facts of this case, what was the evidence before Judge Covert? It indicated that the wife was only making $10,000 a year. There was evidence presented that he was the one that was providing more than 1/2 of the support. So based on the statute somebody could be mega wealthy, but if they provide more than one half of the support, that's somewhat of a child or a dependent. So, and I appreciate the fact they said what the case law says, but I think I circle back to what Judge LaRose said. This is something that the legislature needs to fix, as opposed to us trying to rule against the statute or the cases in this case.
Well, I think it's kind of interesting that Your Honor kept stopping at providing more than one half of the support. The statute,
or no, I read it for a child or other dependent.
Right,
So
and I think.
I said that. No, I've said that. I have it right here. Yes. Sir.
Sorry. So I think the word dependent is where this is all coming from, because
as you get it before, there's really no I mean, is there any case that says what a dependent is? Has there been any definition of a dependent?
Yeah, well, no, but the case is in Ray Holland, which is cited in my brief. It's a Middle District of Florida bankruptcy case out of Jacksonville. That case had similar facts, and it said the chief dichotomy presented by the parties is whether a showing of support or a showing of dependency is the key factor in proving head of family status. So that court separates the support with the dependency. And the court said, this court concludes, as the case law demonstrates, that showing actual dependency is the more important factor rather than the mere existence of some financial support. So you have to look at both of those words. You have to look at the word support and you have to look at the word dependency. The courts have said, don't look so much at support, look so much at dependency. Is this person dependent upon this other person?
Well,
it doesn't matter.
Mr. Jackson, I think you're sort of changing the wording of the statute. You're saying dependent upon as opposed to a dependent of. I think the word dependent there is used to define the nature of the relationship between the person providing the support and the person who is the beneficiary of that support. If you look at the earlier bankruptcy cases, a lot of times this issue would come up in the context. If you look at in Rivera, there was no family because the man and woman were not married, and thus the man was not legally or morally obligated to support the woman. And so I think in that context, dependent means someone who is morally or legally entitled to the support. Because as you point out, the purpose of the statute and the definition that we're looking to is head of family. So whether someone is a dependent defines whether we have a family for purposes of the statute. It's not the person who is dependent upon that support. It is a dependent. And I think that's where the difference in definition, you want to say it means something different than what the earlier case law indicates it means.
Well, I think even the earlier case law sets forth that you can't choose who the head of family is. You can't say, well, you're going to be head of family and I'm not going to be head of family. But that's exactly what these people were doing in this case, the defendants. From 2009 to 2019, they set up their quote unquote family so that Mrs. Stalker was the head of family. All of the bills were paid out of her account. The $200,000 purchase price or down payment for the purchase of the company that they owned together was paid from her personal account. The $50,000 down payment for their boat was paid from.
You have to look beyond that. During that time period, don't you have to consider where the cash was coming from into that checking account?
And again, my understanding is you have to look at the totality of the circumstances. Well, he being Mr. Stalker even admitted that it was set up that way to avoid creditors. He had a creditor from as a result of I think it was a credit card judgment that came in and garnished his account. And he said, I don't want that to happen again. So I'm going to set everything up in my wife's name so that nobody can do that to me again. That's not the purpose of this statute. The case law says you can't use the statute as a sword. You can only use it as a shield. You can't purposely manipulate your family in order to meet the strict language of the statute. And that's what they're doing. And that's what all the case law says you can't do. You can't purposely manipulate things in order to fit under here. The purpose of the statute is to legitimately prevent people from becoming objects of charity and wards of the state. And if you intentionally manipulate your family, as the court has pointed out, the family aspect of this argument, if you intentionally manipulate your family to get around this rule, that's not the purpose of the statute. That's not the legislative intent of the statute. And that's what these cases say, is
So you're saying even if you could fit within the letter of the statute, you're not fitting within the spirit of it.
Correct. You're not. Yes, you're not fitting within the spirit of it. And it goes again to the difference between support and dependency. The spirit of the statute, as again, all of the case law says is, listen, we don't want this person who is making minimum wage to his wages to be garnished, and now he has to look to the government for support, and he has to feel bad about that. His kids have to get free lunch. He loses his mortgage, he loses his rent, he's out on the street. That's the purpose of the statute. The spirit of the statute is that. The spirit of the statute is not somebody who has a company that profits $1 million a year, that intentionally manipulates his family structure, intentionally manipulates his bank accounts so that he can attempt to fit under this, so the legitimate creditor that he owes $767,000 can't get to his assets. That's not the spirit of this statute. All right. So just to answer your questions. So again, we go back and I think that's what some of this case law says is, look, you have to look at the factual circumstances. You have to look at the spirit of the statute. You have to look at the purpose of the statute. And the judge in the lower court, Judge Covert, even says—
Mr. Jackson, let me ask you this, because I know you seen that you were powerless, or at least, your client was powerless to show, and in this kind of context, how much money the husband was making. Couldn't you have brought, or couldn't your client brought out the fact that, well, maybe some of the profit and taxable income of the Hennessy's basically is allocated to the wife in order to prevent her from qualifying as a dependent? There was other methods that you could have at least shown before the court in this case.
Sorry, the court made a specific finding, and I'll read it. I said, this is the court talking. It's clear to me that she is college educated and she's able to work on her own, and she's able to support herself based on the assets that they've accumulated over the years. So that was pointed out.
But the case law, and they said this is not an imputation of income. My question is a bit differently. If you're taking the position she should not qualify as a dependent, couldn't you or couldn't your client bring out the fact that, hey, the profit, the taxable income of the corporation is basically allocated to her, that she's getting all that. And so,
sorry.
Well, but on this record, the only thing that was brought up before the court was the fact that she's only making, and I'm looking at here, let me look at the record here, $10,000. She is, here we go, that she does not have a full-time job. She's earning less than $5,000 a month. There's the Hennessy Corporation CPA, and this is what I was driving at, testified that the amounts reported as income allocated to the wife were not distributed or available for use. So this was an opportunity for you all to kind of attack that or cross-examine that and to kind of break that in order to give the court some sort of evidence to say, hey, she does not qualify as a dependent. So that's what I'm driving at, that you had that opportunity and unfortunately it was not there.
Well, we did do that, Your Honor, and I think the transcript of the 2-hour evidentiary hearing, it was split up into 2 days, but in the 2-hour evidentiary hearing is attached, and on page 232 of that record, it says that there's over $1 million in profit made by Hennessy Construction. It's attributed to both of them equally, and I don't think it's in dispute that.
I think you misunderstood me. All I'm saying is that what is the competent substantial evidence? The evidence that's presented before the court was that this type of income that was available to the corporation was not distributed or not even available for use by the wife. And so the focus is the wife. Is she a dependent for purposes of the statute? This is what I'm driving at, not what the corporation has and how much money it makes. My question is rather specific as to that.
But that's my understanding of what Judge Covert meant when he said she's able to work on her own and she's able to support herself, quote, based on the assets that they've accumulated over the years. So she's not depending on Mr. Stalker for her support. She's accumulated these assets over the years that allow her to be independent of Mr. Stalker. And that goes to one of the other cases that I cited, the Beckman case, where the court
Mr.
said—
Jackson, if I may interrupt you for a
Sure.
moment, you're just about with 4 minutes left of rebuttal time. So
that went quick. That went quickly.
It usually does. Use
Yes.
your time as you wish.
All right. I'll save my last 4 minutes for my rebuttal then.
Thank you, Mr. Jackson.
May it
Mr.
please,
Weber.
thank you, Your Honor. May it please the
Mr.
court.
Weber, could I follow up on something Judge Kuzam raised? I mean, what if anything are we to make of the profits that are allocated to the wife for tax purposes?
Yeah, so Hennessy was a subchapter S corporation, and as a result of that, its profits flow through, but via a K-1 for tax purposes only to the shareholders.
And they are the only shareholders, correct?
Correct, and
Okay.
Mr. Reeder, the CPA, testified that even though they own the entire group of shares as tenants by the entireties and as a moiety, for reporting purposes on federal tax forms, he has to allocate the profit amongst joint tenants. So he gives her a K-1 for 50% and him a K-1 for 50%. But it was clear that that had nothing to do with their rights under state law vis-a-vis the corporation, which was that they jointly owned the stock.
Maybe you can help me out with this then. Are her only assets those that come to her through the corporation? Because I'm a little puzzled by the wording of the judge's order. I mean, what are these other assets that she's accumulated, or are we just talking about the corporate assets?
Yeah, I don't know what other assets he could possibly be referring to. Mr. Stalker testified that because Hennessy was acquired with a small business administration loan, one of the features of that is that you must pledge your home as security for a small business loan. And so even though there was not an institutional mortgage on their home, the home was pledged as additional collateral to the Small Business Administration. So number one, the idea that they could simply go out and access maybe the home or the equity in the home is not supported by the record. But more importantly, Hennessy Construction is a commercial construction company. And the testimony was undisputed that when they purchased this company from the prior owner, Mr. Alexander, he took all of the equity in cash out of the company. And as a result, when Hennessy needed to enter into a new bonding relationship, there were strict covenants that prevented Hennessy's owners, Mark and Catherine Stalker, from withdrawing any profits from the corporation until there was an equity cushion of about 3.5 to 5 million. And of course, as you know, bonding companies and lenders, they never give you anything specific. They say, we'll look at it then as to whether or not we're going to allow you to take profit out. But the testimony was that not only was the K-1 profit that was being distributed to them as income on their K-1s, that had to go to servicing the Small Business Administration debt and building equity in the corporation to satisfy the bonding company. And the testimony was that if the bonding company, if they made a distribution in violation of those covenants and that bond pulled out, Hennessy would immediately fail. because that was essential and critical to its business. And so we cited in our brief the case of Zold versus Zold, which discusses this income, this pass-through income issue in the context of alimony. And in there it says that if there are legitimate business reasons for the corporation to retain capital, working capital, then that income is not available to an alimony payer. And for the same reason, in this case, it was undisputed that income was not available to either Mark or Catherine Stalker for their support, and that the sole means of family support was $10,000 from a pet sitting business that she had and $140,000 salary from Mr. Stalker. The only provision of those covenants that the corporation was bound by that allowed any money to be distributed was simply an amount sufficient to cover their pass-through tax liability, which is a common trait in closely held subchapter S corporations, that because there is phantom income being recognized by the shareholders, the corporation will usually allow enough to cover the tax liability associated with that phantom income. So the Stalkers had phantom income. They didn't have access to that for their day-to-day support. And that is the facts that were presented to the trial court. Other than a boat, which also had a lien on it, I don't know what other assets that Ms. Stalker could have possibly accessed to provide for her own support. And so the facts of this case demonstrate that these parties were married 32 years and that Mr. Stalker was the breadwinner. Now, obviously during the recession, 2009 time period, construction dried up and he went through some difficult times. And that's partially why we're here, of course. But during that period, Catherine started cleaning and working at the Bon Air Hotel in St. Pete Beach for a few years. In 2015, she started the pet sitting business. Now, much is made of this notion that her account was used during this period of time. Certainly, once the wages of Mr. Stalker, the statute is clear, subsection 3 of the statute says those wages remain exempt once you put them into a bank account. And so the notion that his wages were being used to defraud creditors during this 10-year period of time, they're simply incorrect as a matter of law. He can take those wages and deposit them into an account in his mother's name, his wife's name, his own name, and they're exempt from the claims of creditors for 6 months. And there was no evidence that his weekly paycheck lasted longer than 6 months. And
you could appreciate, Mr. Weber, I mean, you could appreciate Judge Covert's concern. And if somebody looks at this, it really doesn't seem right in a way. I mean, it's legal, and what your client did is well within the purview of the law, but it just, my goodness, here's a very successful company. And here's, yes, you mentioned about the boat, and I guess you mentioned there's a lien, but regardless, they have access to this. And to quote Judge Covert, a very expensive boat. It seems unseemly in terms of how this came about. But the question for us, it has nothing to do with seemly, whether it's a policy decision. We just need to apply the law as it stands. So it's far different from what we should or it ought to be, or any type of these global policy decisions.
And that's correct, Your Honor. And let's go back to Wolf versus Commander and the 4th District case. This is not a new issue for courts. In Wolf, back in the 20s, the general manager of the Citrus Exchange was making $10,000 a year and was entitled to this exemption according to the Florida Supreme Court. And the argument was that's scandalous. You could even say people making $50,000 or $80,000 a year would be entitled to this exemption. And this is really only supposed to protect people who are on the verge of poverty. And the Florida Supreme Court says there is no cap on what's protected. An executive like the gentleman and Mr. Commander he was entitled to the exemption. And that's recognized again by the 4th District in Mazzella, saying there's a physician making $100,000 a year, and they're entitled to the exemption. And if you don't like that, you can march up to Tallahassee and you can tell them to change the statute. But what is the statute that we look at? All of the disposable earnings over $750 are exempt. There's no cap on that. The legislature has had decades to change this had they chosen to do so. So I understand the harshness of exemptions when it comes to claiming creditors, and that's something that every lawyer deals with in practice. But the fact of the matter is, Florida has a generous exemption when people title things jointly with a spouse. There's no way around that. A creditor of one spouse can't get to joint assets. That's just a fact of the legal landscape. Similarly, somebody who is the breadwinner and provides the support for their family, it's exempt. Homestead can be very harsh on creditors, but the fact that people are aware of these exemptions and simply provide and take advantage of them is not some kind of evasion of creditors, as Judge Covert might suggest. He recognized it was his duty, just as the court said in Wolf versus Commander, it is not our job to question the wisdom or folly of the exemption. We're a court and we follow the statute. And that's why he did what he did despite his stated misgivings. I would also note, and there was a suggestion in the argument that this was only for minimum wage earners. Again, that's directly contrary to the Florida Supreme Court's opinion and the 4th District's opinion. Furthermore, there was an automobile allowance of $600 that was raised in connection with this appeal. We argue that an expense reimbursement, a true expense reimbursement is not subject to a continuing writ. And there's cases that we've cited on that. The Brock versus Westport case says, yeah, this isn't salary or wages, but for the same reason, you're not entitled to a continuing writ for it. So if it's properly categorized as expense reimbursement, as argued, then the court's duty is to still affirm because a continuing writ simply cannot reach an expense reimbursement. We argued in the alternative that if the court were to consider it as salary or wages, some kind of an unaccountable reimbursement program that might be additional compensation, then again, it would be subject to the exemption. So in either event, the $600 expense reimbursement would either be subject to the exemption or outside the reach of the writ chosen to be pursued in this case. The issue here, as far as the court standard of review, I think is the analysis controls. This is a factual determination. The factual finding was made that Ms. Stalker made $10,000 a year and depended on her husband for support. And the testimony was that the electric bill, the utilities, water, sewer, all the household expenses, the property taxes on the home to insure the home, all of that paid for with Mr. Stalker's salary. And I don't know what support looks like, but just because you may own a home doesn't mean that you can continue to live there forever without paying household bills. And that is what the evidence showed, is that Mr. Stalker is the only person paying those household bills and providing for those things through his income that he derived from Hennessy Construction. And I think the finer point, taking any of the cases cited by the appellant, if you took Mr. Stalker and his work out of this equation, you would be looking at Ms. Stalker being in poverty. She makes $10,000 a year, which is below the federal poverty level. You have to assume that Hennessy would continue to run without him and that she would just magically go to her mailbox and continue to be supported in the way she was. In fact, we know that if Mr. Stalker were no longer in the equation, providing his personal services, Hennessy would not be bondable. And so for all of these reasons, not only a 32-year marriage where Mr. Stalker provided all of the support, save and except She contributed during that 5 years she worked at the Bon Air, that he was the primary means of support for not only the two of them, they had 2 children, and those children are now in their 20s and they still help them out a little. But Mr. Stalker is the head of his family. He has been. It doesn't matter what account his earnings are deposited into, he is the means of support. For these reasons, I would ask that you affirm the trial court's finding. And if you don't have any questions, I will rest on my brief. Thank you.
Thank you, Mr. Weber.
May I proceed, Your Honor?
Yes, you may, Mr. Jackson.
Thank you, sir. Just to kind of expand more on the asset questions that the court had and the asset questions that Mr. Weber brought up. There was testimony that the house, there was no mortgage on the house. There was testimony that they bought this $120,000 boat it was, and they put $50,000 down in 2019. So I don't know how much more is left on the boat, but they put almost 50% of the boat down. With respect to the bonding company, there was questions asked. Much was brought up of the bonding company, of their requirement. I said, well, what are the requirements for the bonding company? We must keep at least $3 million in our bank account per our agreement with the bonding company. I said, okay, so let's say you decide to close up shop, close up your business. Would the bonding company's restrictions hamper you in any way then? They said, no, that we wouldn't have a need for the bonding company because we'd be out of business. I said, well, how much money do you have in your account? They said almost $2 million. I said, so you'd be able to take that $2 million out of your account because you'd have no bonding restrictions at that point. Well, yeah, I guess so. I guess we would. So those are the assets. Those are the type of assets. If they both own the company together, she would be entitled to that money. She would have assets. And to think that she wouldn't have those assets if Mr. Stalker somehow wouldn't perform services for the company anymore, I don't know where counsel's coming up with that, but she'd still have a right to that money. She'd still have the profit to that money. If she wanted to close up that company's shop and take all the money out, she has the right to. That would be $2 million there. She's not going to become a ward of the state. She's not going to become an object of poverty. And that's what the lower court judge was getting at. All of this was presented to the lower court judge. Again, the Wolf versus Commander, it sets forth that you're supposed to look at the purpose of it. That case dealt with the definition of personal services in the statute. The plaintiff was saying, this person doesn't do manual labor, so that can't be considered personal services. The court said, no. It doesn't say manual labor, it says personal services. He fits the definition of personal services. That case had nothing to do with showing that the wife had assets, the wife was dependent. That case had nothing to do with that. In fact, again, that case in the 4th DCA case says, you look at the totality of the circumstances, you look at the spirit of the statute, look at the legislative intent of the statute, and you make your determination on that. The final point I have to make is, as the court pointed out, I went to Florida State. As the court pointed out, Mrs. Stalker is a Florida State graduate. I think she has the ability. I don't think that she, I don't think
See,
that
that's
just
where,
because.
Mr. Jackson, I think those of us that went to University of Florida will take issue with that. No, I'm just teasing.
I was debating on whether to bring that up or not. I knew I shouldn't have brought it up.
And for the record, this is a joke. I don't want people to think I was serious. It's a
I
joke.
immediately regret the decision of bringing this up. But that's my point. And she is a college graduate. She's not mentally disabled. She's not physically disabled. She has the ability, on top of her assets within the corporation, her house, her boat, her own business, she has the ability to earn a living. And that was specifically found by the court. Based on all of this, I would ask your honors to reverse the trial court's December 23rd, 2020 order granting the Mr. Stalker's claim of exemption, and reverse the order granting the order dissolving the writ of garnishment.
Thank you, Mr. Jackson.
Thank you,
Thank you,
judges.
Mr. Weber. That concludes our docket for this morning, and we are adjourned.
Thank you. Thank you, gentlemen.